coming today and joining us here in Nottoway County. I got a few brief comments for you, and then I'll take a few questions, and then we're going to head home. So first, I want to tell you that today for Nottoway County, for the citizens of this town in Maryville, this is a good day. It is an opportunity for this town to heal. But what this day is really about is a very, very young victim. And one of the things we generally get to offer victims through this process is their anonymity. And I intend to do that today and try and restore that today. I'm not sure, of course, that can happen, but I will not be referring to this young woman by name out of respect for that goal for her anonymity. So, at the very heart of this case is this very young girl. And she has been at the heart of my concern, and she has been at the heart of this investigation throughout the case. You heard, some of you may have heard in the courtroom that I stated that the victims did make a statement. They are supportive of this plea agreement, and that is the victim herself and her mother. They are represented by an attorney, John O'Connor. I've spoken with Mr. O'Connor multiple times, and I have, of course, spoken with the mother and her young daughter, and they are both supportive. I'm going to read a statement from them now, but we are going to provide you copies of that statement as well. And this is from the young victim. I want to thank everyone who supported me and my family during these past 2 years. Your support has meant so much to me. Today, I am grateful that the defendant took responsibility by pleading guilty to the charges. I am ready to move forward. To all of those who supported me, I promise that what happened on January the 8th of 2012 will not define me forever. From her mother, this is her statement. I wanted to be present today for this hearing, but have chosen to be with my daughter. I hope that today's resolution of this criminal case brings some closure for my family, especially my children, and for the community. All of us need to come together in a more positive way. So, let me talk a little bit quickly. I know you're sitting out here in the cold and you got to witness part of what happened, so let me talk about procedure. Today, Mr. Burnett was held accountable for his actions. He pled guilty to endangering the welfare of a child in the second degree. And what that means in this particular case is that it is a conviction. It will remain on his record, and it will never go away. There were several special conditions of his probation, but a couple that I want to highlight that I believe are important is that he has to pay a substantial amount of restitution to this young gal, and I'm going to be the one that monitors that along with the probation officer to make sure that she is getting appropriate mental health treatment services. He is going to provide 100 hours of community service, and before we allowed this plea agreement to happen today, there was one plea condition that had to be satisfied, and that was to Mr. Luna and I, who is a chief trial assistant in my office, there had to be a tendering of an apology, an acknowledgement of his wrongdoing, and an actual apology for his conduct. Of course, that is not to us. We are the individuals who received that apology, and at the appropriate time, on the appropriate day, I will convey that apology to the young victim in this case. A couple other things that I want to bring to your attention. Of course, some of you are probably going to ask me, there were no sex charges. Why is that? So, as a prosecutor, I am telling you I stand here by my oath always. And my job is to analyze evidence. In this case, there was insufficient evidence to go forward on a sexual assault. So in this case, every case, it boils down to the evidence, but that's what this case boiled down to. The evidence in the case file, the evidence that I poured through, that is the evidence from the Nottoway County Sheriff's file, from the previous prosecutor's file, and from our own investigation that we have launched in this case. I think the important thing for you to note about that is that our system of justice works because it is evidence-based. We don't always like the outcome, but it is evidence-based, and therefore it works. I trust this system. I believe in this system. It is not always a system where we can triumph, the outcome. But this is an outcome. It is a good day. It's a day that protects this young victim from having to go into this very courtroom and testify, not just through my questions, but of course by defense counsel's questions. And that's a hard task. It's one that we were willing and able to do, but this is the outcome that we believe was the right and just outcome in this case. So I'm going to take a few questions from you.
Ms. Baker, what conclusions should the public draw about the victim's credibility based on this outcome?
You should draw this conclusion. This case was a legal analysis. That is my job. It is a legal analysis, and so that is where your attention should be drawn. That was my job, is to review the evidence, and that's what I did.
You could have pursued a felony charge of child endangerment, which would have been knowingly causing her harm. Instead, you went to misdemeanor criminal negligence. Why not the felony?
We had a lot of discussion about that, and of course, to get to this agreement today, this has been an ongoing discussion with defense counsel for well over a month. We have been working hard toward what charge we were going to level in this case. The felony is certainly was on the table, which is why we are here. Our analysis was, after a long trial and after very possibly further dividing a community, we were going to end up with a misdemeanor conviction of what we have right now.
The former prosecutor had said the family wasn't cooperative, and that was part of the reason you didn't pursue charges. Did you find the family fully cooperative, or was their dealings in this one of the reasons why we didn't go after the sex charge?
Well, let me say a couple of things about that. One, the victims in this case, the victim and her mother, were very cooperative. They worked with me. They helped me walk through the evidence, and we had many discussions throughout the course of my appointment to this case since October of last year. To speak further about what happened prior to that, I cannot speak to that. I was not there. I was not part of the case then, so I don't know. So my analysis was they were supportive of getting to this result today.
But you talk about your analysis of the evidence. You obviously got this case many months after it was first alleged, first investigated. And based on the evidence that you got, was the evidence that you got all hampered by that time lag? Was there evidence that maybe if you would have handled this case from the beginning, that you would have had or been able to accumulate or gotten that was not in the case file that you must have handled?
Well, that's that leads me down a path of doing some hypotheses that I'm not willing to do. I had the evidence I had. It was, when I received the case, we were well past, any kind of anniversary dates here. And as of yesterday was the 2-year anniversary of this horrible night for this victim. So, you can take what you will from that.
Did your evidence Bob Rice? Does this vindicate his decision, which was pursuing the same charges you ended up with?
That would be your analysis to make.
When did you
Anyone
first?
else? I'm not going to speak to that and to her present condition. I think that is inappropriate for me to do so.
When did the defendant know he was going to be arrested and charged with this crime? And when did you speak to the victim? And let them know as well.
I'm sorry?
When was the defendant informed that he was going to be arrested on this charge? And when did you speak to the victim about the plea agreement?
It's not been a single discussion. It's been multiple discussions. They've been in my office, and we've also talked by phone. This plea discussion has been going on for at least a month, and I've had multiple conversations with this family during that period of time.
Ms. Baker.
There's no evidence. We tried to obtain the video, and that video, we were unsuccessful in obtaining that video. So without that, there is no charge there. Anyone else?
Ms. Baker.
I'm sorry?
About the evidence, the rape kit, did you find
That is part of the evidence. The rape kit is part of the evidence, yes. I
This
reviewed
case
that.
closed against not only him, but other people that were involved. Case closed against others.
I believe that, yes, the case is closed regarding Mr. Zeke, who had been originally charged, and obviously against Mr. Barnett.
Ms.
Anyone
Baker,
else?
yeah, did the involvement of any of these outside groups who crowdsourced this investigation end up having any effect at all on how you went through it?
No. Our job is our job, and it's always going to be our job. And so whatever kind of pressure we get is the pressure we get. And my job is to be as tone deaf to that as I possibly can and do my job to the best of my ability and my oath. And that's what we did today, is to bring this result today. I think it's a just result, it's the right result, and I think we're getting probably cold and close to the final question. Anybody else?
Just to clarify the timeline, did you reach this decision on the plea deal before Daisy's recent suicide attempt?
As I said, we have been in discussions regarding this plea agreement for well over a month. So that we have had that discussion weeks ago.
And regarding the apology, did you like tape record something and give like what's can you give any substance as well?
The substance I'm willing to give you, that was a private conversation. I do intend to keep it private, and it is and not discuss it further, because that is something, of course, that Mr. Luna and I will go deliver to the young victim in this case when she is ready to receive it. It was genuine, and I'm going to tell you that I believed it was genuine, and I believed it was heartfelt, and I accepted that so that we could go forward with this plea agreement.
I guess I was just curious, how is he getting it? Are you all going to speak it to him, or was there some
Correct.
recording made?
It was made orally to us through a law office today.
I have copies of press releases. I have the victim's statements that was entered into the record today. So we got